I suspect quite a few people know who I am, but for those of you who don't, I work for a company called MSDS Marine. I'm involved in a wide variety of projects that require some form of marine licensing. This ranges from offshore development right the way through to shipwreck excavations. So marine licensing and its implications has a huge impact on the work I do and how I do it. I'd just like to say I don't work for the MMO, so these are my experiences with marine licensing based on my own experiences of using the system. So the thought of marine licensing can be a bit daunting, and it's often seen as a hindrance to diving activities, or also really expensive. It's really not, and hopefully I can break this down a little bit for you all tonight. I'm not going to go hugely into detail. You'd all be asleep and we'd be here in 3 or 4 hours time. But if anyone has questions after this session is finished, then please do get in touch and I'll try and help wherever I can. So this evening we'll have a look at the Marine and Coastal Access Act, what marine licensing is, exemptions to marine licensing, and then the self-service licensing system. We'll also have a very quick look at the seabed survey license, which is sometimes required, and this comes from the Crown Estate. Hopefully I have time for some questions, but as I said, I'm always happy to help where I can outside of this session. So firstly, the Marine and Coastal Access Act 2009. I won't read this out, but as you can see, it's a multi-purpose act covering a wide range of areas. I remember the uproar within the diving community when it came in, and the act sought to rationalise the existing licensing regimes. So this included the Food and Environment Protection Act, FEPA, and the Coastal Protection Act, which is 1949, the CPA. So while some things changed, a lot didn't. It just brought marine licensing to people's attention. There really was a lot of confusion about what divers could and couldn't do at the start, with contradictory guidance and updates coming out. But nearly 15 years down the line, I'd like to think it's pretty much settled down. So the Marine Management Organisation, or the MMO as they're commonly called, was created under the Act to administer it, including licensing and regulation. Of relevance to this session is primarily planning and licensing for marine construction, deposits and dredging that may have an environmental, economic or social impact. The MMO also have enforcement powers, which they do use. So I've just put this photo up here as a reminder. This was a few years back on a shipwreck excavation we were working on, and we were boarded by the MMO and the Kent Police to make sure that we had a marine licence in place and that we were only doing activities that were allowed underneath it. The biggest question is always going to be, do I need a marine licence? And the answer to this is generally, if it's a recreational diving activity, then probably not. The MMO have also put together a list of activities specifically related to recreational diving. So as you can see, this includes things like anchoring at a dive site. We don't need a licence. We can put a shot marker in for up to 24 hours and actually up to 28 days, although we have to notify them. We can survey dive sites, we can make removals by hands, we can clean up marine litter. The one that I always find slightly amusing is that we're allowed to ascend from a dive. We don't need a licence for that, thankfully. But then there are things that do need a licence, such as leaving a shot in for longer than 28 days, or removals that aren't by hand, so using a boat, a winch, a lift bag, etc. So the requirement for removals can be quite simply summarised. There are a few anomalies that may not seem to make sense, but the overarching factor is the use of a vessel or associated equipment to make the recovery, and equally this applies to a deposit. So recoveries by hand do not need a marine licence. Recovery by any other method will. A deposit, so putting something on the seabed, not using a vessel doesn't need a licence. However, as soon as you take that item onto a vessel, you need a marine licence. So if you wanted to make a deposit without a licence, it would effectively mean swimming from the shore to the site. As soon as you jump on a boat, you need a licence. So let's have a quick look at some of the types of licences. So the MMO have a handy tool for assessing whether you need a marine licence and what type of licence you will need. So there's a QR code on the slide. So if you scan that, it will take you directly to that licence assessment tool. Exemptions, we've had a look at briefly, and these are covered under some of the things recreational divers can do. They also cover a lot of what an archaeologist would also need to do. We're not going to talk about the standard marine licence. I really suspect that these would fall well outside the scope of what most people here tonight would want to achieve. And as you can see, the costs are quite high. And this is just the cost of the licence. There'll also be a requirement to ensure compliance with a number of areas. all of which may require research and reports to be written in order to comply with these. If it's something that you think you will need to do, then please do get in touch and I can talk you through it. Most archaeological works can be covered with what is called a self-service marine license. So these are activities the MMO have deemed as low risk, and the process of application is actually generally quite straightforward. We're going to have a look at this tonight. We'll leave the standard marine licenses. So marine licenses are required for the listed activities, and these are the headings that the MMO use. And of relevance to us are dredging or excavation, to put it into an archaeological context, and then removals. Within the normal limits of what we'd be doing as archaeologists, these activities, if they're not exempt, should be covered by a self-service marine license. There are, however, a few things to note. So the project can only, or the license will only last for a period of 12 months from the issue date. So you have to complete what you're doing on that license within 1 year. This is for small projects, so larger projects or where there's a smaller component of a larger project, you have to go through the environmental impact assessment process, and this goes through the standard marine license procedure. The area cannot cover more than 10 square miles, which would be a huge shipwreck if we had to go up to that limit. But if you're looking at multiple locations, the total area cannot exceed 10 square miles, and each location must not be more than 10 miles from the other one. It also needs to fall within the MMO license jurisdiction, which, as you can see from the chart on there, is fairly extensive. So the MMO jurisdiction is pretty much from here, normal tidal limit, right the way past 200 nautical miles. It's also worth noting that every application will go onto a public register. There's exceptions to this if it be in the interest of national security or if there's confidentiality provided by law to protect legitimate commercial interest. So the site location, this is probably the hardest bit of marine licensing in terms of self-service, but it's critical to the process. So they will ask you a number of questions that relate to the proximity to certain areas, such as those used for military or defence purposes, and in which case you need permission from the MOD, whether it's close to cables, pipelines, whether it's an IMO routing, whether it's a protected place under the Protection of Military Remains Act, if it's a heritage designation, etc. Also MPA, so marine protected areas such as conservation zones, special areas of interest, SSSIs, etc. If the project does fall close to any of these, then you'll have to provide a method statement outlining what you're going to do and how it's not going to impact these things. So for an MCZ, for example, you'd have to demonstrate that you weren't going to cause an adverse impact within that area. And it's up to you as the applicant to ensure that the relevant sensitivities or the relevant areas have been researched. Now, again, the MMO have a very handy tool for doing this, and it's actually a really, really useful GIS map anyway for looking at where all manner of things are, so wind farms, cables, pipelines, etc., etc. Again, we've got a QR code on there. You can give it a scan, and it will take you to the GIS mapping page. So you put in the location of your project, and it will tell you whether you're near an MPA, whether you're near an existing wind farm, MOD area, etc. So it's a really, really, really good resource. So some of the activities that a self-service license can be used for. So first off is dredging. This is the biggest one, or in an archaeological sense, we'll call it excavating. So again, there's a lot of text here. I won't read it all out, but the main thing to note is that to be considered for a self-service license, you're only allowed to take 1,500 cubic meters of material away in 12 months, or 500 cubic meters in a single dredge. Now that's quite a lot. Within a shipwreck excavation, we're never likely to actually exceed that. This applies to any wrecks, whether they're designated or not, and a method statement will need to be approved by Historic England, and we'll talk about that shortly. So next up, recoveries from designated sites. So these are sites that are protected under the Protection of Wrecks Act or Scheduled Ancient Monuments. This is also not intended to enable the recovery of a complete shipwreck. This is for discrete minor objects or artifacts from the seabed. They will require, if it's on a designated site, you're going to need a designated site license. So for ones under the Protection of Wrecks Act, Historic England administer these on behalf of DCMS. But in order to do this work, you would also need to have an approved method statement from Historic England. If you have a surface recovery license and you do work on a protected site, having that surface recovery license from Historic England, it infers that there's been an improved method statement. Just remember as well, this is recoveries not been made by hand. Recoveries by hand, if we remember, that they are exempt. So again, it's pretty much the same for non-designated sites. If the items to be recovered are or intended to establish the presence of material of archaeological or historical interest. And again, there must be an approved method statement with Historic England. And there'll be a tick box as you go through the self-service license. You tick to say you have it. There is a method statement template which can be used, and this is on the MMO self-service portal, and you can get a link directly to this. And it looks something like this. So we go through and we fill in our methodology, how we're going to mitigate any impacts, and the program of work and what we're looking to do. So again, it sometimes looks a bit daunting, but as you actually get into it, it's not too bad. This doesn't have to be submitted in this format. It can be submitted as a standalone method statement, as long as you include all the information they need. This has to be agreed, though, with Historic England prior to the submission of a self-service application. So the application for self-service license is undertaken through the MMO Marine Case Management System. This is the only way to apply for it. And to do this, you will be required to create an account. Again, it's a very straightforward process and it's prompted all the way through, but it's very worth going through the do I need a marine license process first to establish if any method statements other than those from Historic England are needed. And we need to make sure as well the project doesn't take place in any areas that may require a standard marine license. So once at the end of the process, you'll be asked to pay a £50 fee using a credit or debit card, and that's it, job done. Well, almost. There's some more information that the MMO will require prior to the start of the project, and these are known as returns. So these are just basically details that you need to provide to the MMO, and it's generally who's going to be working on the site, what vessel you're going to be using, etc., etc. So just lets them keep a record of what's going on. So when they start to look at enforcement, they know who should or shouldn't be working on that site. And that's it. Easy, sort of. Although just to throw a bit of a small spanner in the works, there may be another license that's required. And this is the seabed survey license from the Crown Estate. It's generally only required for excavation where airlifts and heavy-ish machinery are used, but you need to check the requirements. So on the screen here, we can see we don't need a seabed survey license if we're hand fannings, non-intrusive, small-scale survey or small-scale retrieval of artifacts. And this is used divers, ROVs, hand fanning, etc. But we are going to need a seabed survey license if we're using airlifts or if we're mooring on the seabed for a period longer than 72 hours. There is a cost to this. It's generally £500, but there's a £100 concessionary rate if you're an independent researcher. So if you're doing it on behalf of a university or a university course, if you're a local council, or if it's for non-profit archaeological wreck investigations. So licensees on wrecks, for example, would be they'd be charged at the £100 rate. But it is also worth noting that Historic England hold a seabed survey license for all of the designated wrecks, and some that are also being considered for designation. So this generally means that if a project is commissioned by Historic England, or if it's in relation to works on a designated site, this license will already be in place. So it's not something that we need to go through. And there we go. That was a bite-sized introduction to marine licensing.
Lovely. Thank you, everybody, for logging in tonight and this webinar. And it's a good way of me trying to introduce myself to some of you, as I'm relatively new in the role. So this is a short presentation on what the Receiver of the Wreck does, and especially in respect of Chapter 9 of the Merchant Shipping Act. So it wouldn't be a talk about the Receiver of the Wreck unless I went into some of the history behind it. So who is and what is the Receiver of the Wreck? So as many of you know, this is quite an historic role. In fact, over the centuries, wreck and salvage legislation has evolved, and the Crown's rights to wreck were enshrined in various versions of the Merchant Shipping Act. It was first created as a specific role in the Merchant Shipping Act 1854, and the Receiver of the Wreck was tasked with administering the Crown's ownership of wreck and acting as representatives of the Crown. The Receiver of the Wreck's role was largely to address looting of ships' wrecks and to encourage and reward legitimate salvage. Now, this is back in sort of 1854, is a time of poverty. And so there was some discussion around what people on the coastal towns were doing in terms of sort of luring vessels to the shore to crash and obviously take the loot from the vessel, which was known as wrecking. The actual extent of wrecking practice is a matter of debate among historians. The English were known to be merciless and savage in the event of a shipwreck. This was so much so that actually the receiver of the wreck had the power to carry, arm, and kill, maim, or hurt anybody that obstructed their duties. And we were fully indemnified against any legal action. Unfortunately, that came away from us in the 1995 Act, but up until that point, we could still carry a sword, apparently. Now, the receiver of the wreck through time, so as we've covered, we could kill and maim or hurt anybody. And so prior to 1992, there were 150 receivers and deputy receivers dotted around the coast of the UK. Since 1992, that receiver of the wreck is now a single post and is part of the Maritime and Coast Guard Agency. And we can appoint Coast Guard officers as the receiver's local representatives. Over to you, Kate.
Thank you, Steve. Next slide, please. All right, so now we operate under the current legislation of, as Steve mentioned, the 1995 Merchant Shipping Act, Part 9. The purpose of this legislation is to protect the rights of wreck owners, legitimate salvors, and the Crown, and to hold each of these stakeholders equally in line with each other. So more specifically, to protect the rights of wreck owners to have their property returned to them, to reward legitimate salvors for their services, and to protect the broader interests of the Crown. In regards to wreck material, I also want to say we operate across the UK, so England, Wales, North Ireland, and Scotland. It's worth mentioning that Isle of Man, Guernsey, Jersey, Sark, Alderney, and all the British overseas territories have their own receivers of wreck and their own separate wreck legislation, so it works differently there. And if you're ever working out there, you'll need to tune into how it works there. And the premise of Roe is to assume that all wreck, no matter how old, has an owner, and the owner has a right to have their belongings returned to them. We also commit to treating all stakeholders fairly, consistently, and impartially. And this slide speaks to that as well. To the key aim is to reunite owner and property and to ensure fair salvage awards, and to dispose of any unclaimed wreck that falls to the Crown. Next slide, please. So we do have some very unique powers, unique to our role, which are spelled out in the Merchant Shipping Act. We have the power to detain vessels, cargo, and equipment. We can sell detained property, commandeer vehicles. We have right of way across private land. We have powers of entry and to board vessels. We can search vessels or premises, seize and detain property, and we can demand the immediate handover of wreck material. Now, this is really very rarely used, but an example when it does get used is the very famous wreck of the MSC Napoli, which happened in 2007. So just to refresh your memories, or in case there's anybody who doesn't know, the MSC Napoli was a container ship. It had its hull damaged during a storm off the coast of the Lizard in Cornwall, and that led to the crew abandoning ship, and the ship was deliberately beached. 103 containers were lost. Some of these washed up along the south coast from Cornwall to the Isle of Wight, and some landed up in down in Dorset. They contained a whole range of things. Some of them contained dangerous chemicals, although I was discussing this with Steve today and they never beached those ones. But others had BMW motorbikes, car parts, perfumes, nappies, and people in their hundreds, in some instances, mobbed the containers and in some instances began to loot. And there were even a few cases of containers being set on fire. So the Roe at the time used their powers. They deputized their powers to the police, Coast Guard, and National Trust staff. So they were all working on behalf of the Roe to manage beach access and try and deter scavenging, but also to encourage those cases of legitimate salvage. And there were legitimate salvages made from some of these containers, which were already broken. They were already open as a part of the wrecking. They weren't opened by people necessarily. And some of those people who made those recoveries were allowed to keep their recoveries, and that included things like BMW motorbikes, which were a bit salty, and BMW decided that they would just claim the insurance and people could keep those. So some people got some very nice fines in lieu of salvage from the MSC Napoli. But that's a very famous case of these powers being used. Next slide, please. Okay, so what is wreck? Okay, so the legal definition of wreck includes any part of a vessel, aircraft, or hovercraft, cargo, or equipment, all wrecked from the sea, under the sea, or washed ashore from tidal waters, regardless of age, size, or apparent importance or value. It doesn't always include, or doesn't generally include, vessels that come off their moorings or stolen vessels. Our jurisdiction extends from the high tide mark to the 12 nautical mile limit, and any fines that are also landed at UK ports that are brought in from international waters. It also includes, because it's an old act, as we've covered, it also includes spacecraft and buoys and nets from fishing equipment. But our remit does not cover lakes, lochs, or rivers that are beyond tidal reach. Next slide, please. So the legislation itself breaks down the definition of wreck into flotsam, jetsam, derelict, and lagan. Most of what comes to us we would consider to be derelict. It depends on how old it is, really, but that's the most common of these. I'm going to continue. Thank you. So what happens next? Our main, when wreck material is reported to us, and I'll go into that shortly, our main goal is to find the owner. So, oh, actually, no, I'll talk about how to report it. Sorry, go forward again. Thank you. All right, so how to report. Okay, sorry, this is...
I'll take over this bit then, Kate. So,
okay, thanks.
So we're looking at acts or chapters within the Merchant Shipping Act, or parts of the Merchant Shipping Act, which really applies to people that are diving on vessels or visiting vessels. And these are the things that are really important to us. And this is to do with section 2 through 6, the duty of the finder. So any person finding or taking possession of a wreck shall report it to the receiver. They shall describe the mark by which it may be recognized and provide photos. They should provide separate reports for separate days, locations of recovery. So we give something we call it a droit, and this could be anything. It could be a number of items, but it's generally grouped together in the days that you found those items. So if you recover 5 items on the Monday and you recover 3 items on the Tuesday, you'll get 2 droit numbers, one which will cover the 5 items on the first day and 3 items on the second day. The thing to be stressed is that you have got 28 days to report that find. That's brought in line. It's not actually in the Merchant Shipping Act, before somebody raised the question about it, but it is something that's been implemented as policy from really day dot of the receiver of the wreck days. In terms of the Treasure Act gives you 14 days because it wasn't set in law. It's being accepted in courts that 28 days is a reasonable limit for you to report your fines. Now, there are occasions where that might not be possible, and what we would say is just contact the receiver of the wreck if you go over those 28 days and let us know, because there are always mitigating factors behind things and we'll take those into account. And obviously the big one is failure to report wreck is a criminal offence. Section 237, cargo. So this is again another section of the Act. Any cargo or other articles belonging to or separated from wrecked or stranded vessel, washed on shore, otherwise lost or taken from the vessel, shall be delivered to the receiver. An offence is committed if any person conceals or keeps possession of any such cargo or article, or refuses to deliver cargo or item to the receiver. The receiver can take any such cargo by force from a person who fails to deliver it. Again, I just highlighted the fact that just please, if you find anything, report it within those 28 days. Section 245, this is taking wreck to a foreign port. And again, any offence is committed if a person takes into a foreign port and sells part of the cargo or equipment or anything belonging to any vessel stranded or derelict found or near the coast of the UK, or any wreck found within our waters. And again, we probably apply the 12 nautical miles to that rule. Section 246, interfering with wreck. It's an offence that is committed if any person conceals any wreck or defaces any wreck. What I must stress about Part 9 of the Merchant Shipping Act is that this predominantly hasn't changed that much since 1854. The wording in some of it has been changed to bring it up to times, but a lot of the laws haven't been changed. And so there is always a little bit of debate over the interpretation of the rules, but those are something that obviously we take into account. But ultimately, we will make a decision based on what is written into the Act and how we interpret it. Over to you, Kate.
Thank you. So this is our online reporting webpage for reporting wreck material. You can still report to us. We have a sort of paper-based PDF that you can fill out, and you can email that to us, and we can manually put in information. But this is the faster way and the easier way to report to us. So you can find this by going to the website below, or you can just Google or use whatever search engine you prefer. Just look up report wreck material receiver of wreck or something like that, and you will find your way here. I'm not going to go through it blow by blow because that would we don't really have time for that tonight. We will be rolling out training over the course of the year. But it is fairly straightforward. All you really need is a photo of the item, the storage address, and the details of where you found it, or as much information as you have. The more information you can give us about where and the details you found it, especially if it's from an unknown wreck or it's an isolated find, the more you give us, the easier it is for us to do our research. It just gives us that head start. Next slide, please. This is the indemnity that we require people to sign up to. It's obviously, when it's online, it's a sort of digital agreement, which is the same as the paper one. When you do it, I'll let you familiarize yourself with it. It hasn't changed at all. Next slide, please. A few notes on care and conservation of items. It's very important to stipulate we are not a heritage or conservation authority. We are there primarily, as we said at the beginning, to unite owners with their belongings and to administer salvage awards. So we are not conservators ourselves. So what we will do, as we've said, we'll act to protect your owner's rights. We'll advocate for first aid for recovered items, and we will usually coordinate with our partners. So that's heritage regulators and authorities and experts in the field in the public interest. If there is a need for specialist conservation, we will usually direct finders towards those resources and support. Sometimes, very rarely, we will also assist to arrange for example, museums to help house objects while they're going through ownership research and going through the statutory requirements. Sometimes we also have to request things like proof of firearm safety certification. It's very rare, but we have had to request that in the past once or twice. Yeah, next slide, please. Okay, so ownership research. This is what we spend most of our time doing. So our job is to identify who is the owner of whatever vessel or cargo or wreck material comes to us. We have a statutory year to, well, there is a statutory year for an owner to come forward to us, minimum, for us to try and find an owner in that year. After a year, the ownership of the item passes to the Crown, and we can, if we can't find an owner or an owner hasn't come forward, we can then decide on a pathway for that, what is the most appropriate outcome for that item. Sometimes if it is very convoluted, we may continue ownership research beyond that, or negotiations. It depends on the item. So it's always a case-by-case situation. But that's our goal, and that's what we try and achieve. So we notify Lloyds for any recoveries valued over £5,000. So that happens immediately within 48 hours of a droit coming to us. And sorry, I'm just looking at the screen. And then the wreck material is held by the salver on indemnity to us in the meantime. Research into identification, obviously we go to the Lloyds records, we do archival research, we tap into expert knowledge that includes our diver community as well, and our archaeological community. We use whatever it is that we need to. We use Coast Guard resources, and it depends entirely because there's such a range of items that come to us from all ages. So it really is, you never really know what's going to land on your desk. And something very important, if it's of historic importance, we'll always seek advice and from experts specific to those items and the wrecks. And we always take salvors' wishes into consideration. Next slide, please. Tips for a timely closure. As we've said, make your report within 28 days. Make sure you include at least one image of the item with any inscriptions, makers, marks, or diagnostic features clearly shown. That just stops us having to go back and forth trying to request that information if it's there. Give us an exact location as possible. Keep your contact details up to date with us so we can apply that to, if you have multiple droits, to all of your droits. If you are doing any of your own research, it's great to have you share that with us as well. We have to verify things independently. We have to do that ourselves, but sometimes that can, really help progress a droit. Let's see. Yes. Next slide, please.
Okay, so
thank you.
In terms of the different outcomes, as Kate alluded to beforehand, within or after 12 months, there are two possible outcomes. Either the owner is found or the owner is not found. So if we talk about if an owner is found first, so we will negotiate a salvage award return of the item to the owner, or the owner waives his rights or her rights and ownership of the item is awarded to the salvor in lieu of a salvage award. So the act of salvage must benefit the owner. It must be made safely. The recovered wreck material must be brought out of danger to a place of safety, and it must be within the law. The finder's entitlement to a salvage award acknowledges the finder's service to the owner and provides an incentive to honesty. The salvage awards are based on criteria which are set out in the International Salvage Convention 1989, which are built into the 1995 Merchant Shipping Act. So we'll consider the value of the material recovered. This is what we consider if we're going to award a salvage fee. The value of the material recovered, the salvor's competency, which is a measure of their success in the salvage operation and the skills they have and the nature and degree of danger they were exposed to. It also covers the agreements between the salvor and the owner. So I can also add that the award can never exceed the value of the items recovered, and that any expenses that we get, and that will come from valuation fees, transport, they'll all be taken out of the salvage fee that's awarded. If the owner is not found. So if the owner is not found, the wreck becomes the property of the Crown if it's within UK waters. And that's important in respect of anything within 12 nautical miles becomes the property of the Crown. If it's outside of the 12 nautical miles, then obviously it becomes the property of the owner if an owner is located, or it will potentially be returned to the salvor if we can't agree with the salvor that it may be worthwhile going to a museum. So on behalf of the Crown, the receiver of the wreck arranges the sale of the item, can do any of these really, sale of the item via an auction, and the salvage award is a salvage award. It could be donated to an appropriate museum. It could be sold to a museum. The ownership of the item is awarded to the salvor in lieu of a salvage award, and I'll come on to that a little bit later in terms of that tends to happen a lot of the time. Or the item, in rare cases, the item is confiscated and destroyed. So I've got a slide from the 2020 outcomes. I haven't got one for last year yet, but this you'll quite clearly see that 85% of the fines that were reported to us were given to the finers in lieu of the owner paying a salvage award. So that means that it basically got given to the owner without any expense whatsoever. 2% of the items were donated by finders directly to museums. Now, this is something that we're very keen to try and avoid that happening, because we can't keep track of those items. And a lot of the time, some of those items may be donated without actually the knowing who the owner is. So that particular item might belong to the Ministry of Defence. It could belong to the Department for Transport because they insured the vessel. And it's very difficult for us to get that item back, or embarrassing for us when we demand the return of that item when it's already been gifted. So by all means, it's really good to have a museum that wants to take these items, but it just needs to be cleared with us first to make sure that the owner is quite happy for that to be given to a museum. 1% of fines were returned to the owner, with the owner paying a salvage award to the finder, and 12% of items were closed through different arrangements in agreement with the finder and the owner. Just go through some sort of common fines. Kate, do you want to go through these?
Yeah, sure. Okay, so these are really common, is cutlery and crockery, and obviously you guys are familiar with the importance of ship bells and plates for identifying ships. These are very commonly reported to us because they're so important for identifying wrecks. And there's a shot here of an entire vessel. I had one of those I was dealing with today. Next slide, please. Historic wrecks, we get everything because it's reported to us through archaeological investigations. So a lot of these are very small finds, but every single item needs to be reported to us. This is the Hulls Whale, which I'm sure many people are familiar with. Next one, please. This is the Kiara, which I'm sure many people here have dived on. It's a very popular wreck. And again, I like this shot because those two items at the bottom, I think these are actually amnesty droits from record, but they're actually leather boots on the left, which I find fascinating. And I think those are balls of yarn on the right, which were preserved, which is very special. But yes, again, all of these are reported to us. Next one, please. Isolated finds. This was really nice. This was a archaeological community outreach project by the Glamorgan Gwent Archaeological Trust, and they recovered this ship's wheel. It was, as I mentioned, an isolated find. We couldn't find anything near it to associate it with any particular wreck, and we weren't able to find any museums who were particularly interested. We actually gave it back, lieu of salvage, to the trust, who themselves then, after the droit was closed, they arranged for it to go to a local. Actually, they did arrange for it to go to a local museum afterwards, but they weren't able to take it at the time because they were undergoing renovation. But it's a really nice story of everybody pitching in to find something. Sorry, to get things where they needed to go. Okay, next one. Okay. Was I speaking to this one, Steve? I think I was. All right. So as we've mentioned at the beginning, we administer the Merchant Shipping Act, Part 9, which relates to wreck and salvage. But we interact with all of these and more. So in particular, many of you will be familiar with the Protection of Wrecks Act. I'm sure you know it in and out. The International Salvage Convention, 1989, informs, as Steve said, how we administer and award our salvage awards. Protection of Military Remains Act, 1986, obviously pertains to many Ministry of Defence wrecks, not just naval wrecks going back through time, but aircraft wrecks as well. The Historic Marine Protected Areas under the Marine Scotland Act is another Scottish equivalent of the Protection of Wrecks Act. Even though the UK hasn't ratified UNESCO, it is something that there's a lot of discussion about, so we're familiar with it. That's a topic for another day. And we've mentioned the Marine and Coastal Access Act, I think. Did we? Was that? Yeah, that was for the MMO. The Theft Act, the Fraud Act, it just goes on. The Treasures Act is really interesting comparing it. We interact with that one quite a lot because obviously a lot of items are reported to us and we have to coordinate with flows and with PAS about, okay, is it us or is it you? Or can, in some cases, things be recorded by PAS, even though they have to be officially reported to us? So we have quite a bit of interaction with them. And it's very interesting because, as you've seen, the criteria for REC is completely different to the criteria for Treasures Act. So that's quite an interesting one. And then the Ancient Monuments and Archaeological Areas Act is for scheduled ancient monuments, which includes some REC sites. Next one, please. Steve has already gone through some of the offences under the Merchant Shipping Act. So again, just to reiterate, failure to report is a fine and can result in imprisonment. So that's really the most important one that we want everybody to avoid. Taking REC material out of the UK to sell that's can lead to imprisonment as well, and concealing REC and defacing REC or defacing identifying marks can result in quite a significant fine as well. And yeah, we've discussed, as Mark was talking about in his presentation, about under the MMO, the importance of not removing material without a license from a protected site, or really from a whole range of contexts as well. All right, next. I think that's us.
That's it. We're done.